We will have 12 minutes for each of the panelists, and Jean is going to be helping keep the time. We do want to have time for Q&A, so I will also help Jean in keeping the time on this, but we'll start off with Professor Ross.
All right, hello everyone. So I only have 12 minutes, so I'll save my jokes till the end. I usually have about 3 minutes of lead up with jokes, but let me just kind of jump right in terms of, thinking about this panel, and the focus on this panel is on opportunities within the current jurisprudential framework for reform. And this, I think, for me, requires that you actually engage with the jurisprudential framework, engage with doctrine. I think that that's kind of a bit old-fashioned for legal academics to do, to actually engage in doctrine, but we're going to kind of go back into the Wayback Machine and actually do so. And I want to start with a couple definitions and then engage in sort of the doctrine, the particular jurisprudential obstacles to campaign finance reform, and what can be done to ameliorate those obstacles. Now, I'll start with definitions, right? So the definitions have to do with over-inclusive and under-inclusive laws. So over-inclusive laws, for those that are not lawyers in the room, or even those that are lawyers, are laws that regulate more than is necessary to accomplish the legislative goal. And under-inclusive laws, by contrast, are, of course, laws that regulate less than is necessary to accomplish legislative goals. Now, over-inclusiveness and under-inclusiveness, these are problems that impact all general rule-like mandates. Courts ordinarily find a degree of over-inclusiveness and under-inclusiveness in laws to be constitutionally permissible. For example, you can think about the equal protection context. In the equal protection context, the court over-inclusiveness and under-inclusiveness does not, or over-inclusiveness in particular, doesn't raise constitutional problems except in those rare instances in which laws target suspect and quasi-suspect classes, right? Similarly, the courts are willing to allow for some over and under-inclusiveness with respect to laws that target speech, so long as those restrictions are content or viewpoint neutral. But over-inclusiveness and under-inclusiveness raise unique concerns in the campaign finance regulatory space. Now, the court has determined that campaign finance laws targeting expenditures are regulations of speech, and speech is it's regulations of political speech, and political speech is considered to be at the core of the First Amendment and the core of the protections that the court provides to speech. And campaign finance laws are therefore, that target expenditures are therefore subject to the highest form of scrutiny. Further, in the First Amendment context, to the extent that the regulations of expenditures are or might be over-inclusive, there is an additional concern that such laws might deter speech or chill speech. An overbroad campaign finance law that regulates constitutional speech, or a vague campaign finance rule that potentially regulates constitutional speech, might deter a speaker from engaging in that constitutional speech for fear of prosecution under that law. Now, this concern about chilling constitutional speech in the First Amendment context demands that legislators be really precise in their regulation of speech to ensure that that regulation only regulates or regulates little to no constitutional speech. Now, the results of the application of this chilling effects doctrine are judicially and legislatively revised rules that are often under-inclusive. Now, these under-inclusive rules are rules that get at some of the constitutionally unprotected speech that legislators seek to regulate and provide clear immunity to that which is constitutional speech. And in most First Amendment contexts, we are not particularly concerned about this under-inclusiveness, or we're willing to accept under-inclusiveness as a cost to protecting fundamental speech values. But in the campaign finance context, the cost of under-inclusive laws are higher than in other First Amendment contexts. In the ordinary First Amendment context, the under-inclusiveness of constitutionally unprotected speech implicates state interests. And even if we account for the fact that certain state interests rise to a level of compellingness, these state interests are still subordinate to the interests implicated in constitutional disputes involving campaign finance rules. While the court in its campaign finance jurisprudence has characterized the interest balanced against the First Amendment freedom of speech as the compelling state interest in preventing corruption or the avoidance of corruption, what really falls on the other side of the balance is a broader constitutional value that has been defined in several different ways by justices and scholars. Defined as electoral integrity, distortion of the representative process, fair and effective representation, equality. However it might be defined, the value has direct constitutional roots in both doctrine and text. But having said that, I want to be mindful of the title of this panel, Policy Proposals Within the Existing Jurisprudence. While certain justices and scholars have identified constitutional values as being on the other side of the balance when evaluating whether certain campaign finance rules violate the First Amendment, the fact remains that a majority of the Supreme Court has not yet gone that far. And while the death of Justice Scalia may create an opening for reconsideration, it is important to recognize the legitimacy concerns that a new court might have with reversing or being perceived as moving far away from the old court's jurisprudence. But there is an important jurisprudential opening that might ameliorate these legitimacy concerns and yet properly place constitutional values on the other side of the balance in dispute over campaign finance laws. And that is through the sleeping giant in the campaign finance jurisprudence that has not yet been fully exploited, the state interest in preventing the appearance of corruption. Now, according to the language of Buckley, quote, of almost equal concern as the danger of actual quid pro quo arrangements is the impact of the appearance of corruption stemming from public awareness of the opportunities for abuse inherent in a regime of large individual financial contributions. The court continues, Congress could legitimately conclude that the avoidance of the appearance of improper influence is critical if confidence in the system of representative government is not to be eroded to a disastrous extent. While the court ultimately invalidated the Federal Election Campaign Act limits on independent expenditures in Buckley, the new court can make a clear case that the context and perception of independent expenditures have changed. Heck, a strong case can be made that the public perception of independent expenditures has changed since Citizens United and Speech Now opened the door to the super PAC and huge amounts of undisclosed money that has flooded into the system since. Now, I'll say that the appearance of corruption is a sleeping giant because the interests can serve as a vessel into which the court can pour constitutional values, such as electoral integrity, fair and effective representation, anti-distortion, and ultimately equality. It is the appearance of that the electoral process is not serving these values that erodes confidence in the system of representative government to a disastrous extent. Now, if it accepts constitutional values as being on the other side of the First Amendment balance in campaign finance disputes, the under-inclusiveness of laws takes on a different meaning. Now, when the law is under-inclusive, it means that the constitutional rights and the constitutional values of the republic are not being protected to their fullest extent. And suddenly you have a dilemma. An overbroad campaign finance rule results in the regulation of constitutional speech and also deters individuals from engaging in constitutional speech. And as a result, that is in tension with the great protection the court provides to political speech. But if the court then revises and forces the state to maintain an under-inclusive campaign finance law, the result is the under-protection of constitutional values embedded within the avoidance of the appearance of corruption. So what gives and what to do? Now, one option is to replace the more generalized campaign finance rules that have the tendency to be either over or under-inclusive with campaign finance standards that require case-by-case considerations of factual context. Such case-by-case consideration of factual context may lead the court to decide that a particular advertisement that refers to a clearly identified candidate within 60 days of the general election is an issue ad, and find that another ad that shares these same features to be an electioneering communication because of factual considerations, such as who issued the ad, whether the group issuing the ad engaged in express advocacy opposing or supporting the candidate in other contexts, whether the issue described in the ad is part of an ongoing political controversy that explains its timing. Third, whether the ad is only targeted at some of the legislators involved in the political controversy, and that targeting is based on partisan affiliation. And the court might consider other factual contextual factors as well. Now, on the other side, when considering whether the ad creates the appearance of corruption, considerations that might be relevant include whether those responsible for the ad are undisclosed, whether major corporations spending from their general treasuries rather than through their PAC funded the ad, and other factors that the court might also consider relevant. Now, such a standard-based case-by-case approach should reduce problems of over and under-inclusiveness regarding the regulation of electioneering communications, but also the regulation of corporate spending. But it must be acknowledged that a case-by-case approach would introduce other problems having to do with inconsistent judicial determinations, and it might increase legal uncertainty for potential speakers, as it would not provide the bright-line legal guidance that a rule is more likely to contain. But we might be willing to accept these costs in light of the gains from a campaign finance regime that is better able to balance First Amendment rights with the constitutional values on the other side. But returning once again to the theme of the panel, would such an approach work within the existing jurisprudential framework? Perhaps not. In both Wisconsin Right to Life and Citizens United, the majority raised what seemed to be a new type of chilling effect concern. In Wisconsin Right to Life, the court explained that in order to safeguard freedom of speech, the proper standard for an as-applied challenge to the Bipartisan Campaign Reform Act prohibition on electioneering communications must be objective, focusing on the substance of the communication rather than amorphous considerations of intent and effect. Now, that part of the judicial determination still might be consistent with a standard-based approach that I described above. But then the court continues, the proper standard must entail minimal of any discovery to allow parties to resolve disputes quickly without chilling speech through the threat of burdensome litigation. And it must eschew the open-ended rough and tumble of factors which invites complex arguments in a trial court and virtually inevitable appeal. Now, the source of the chilling effect concern, according to the court in Wisconsin Right to Life, seemed to be the potential for litigation that requires fact-based determinations to resolve constitutional claims. And it is this cost, these costs and the time and the uncertainty with litigation that is to be avoided. So what is the best way to avoid that? Well, according to the Wisconsin Right to Life, it was the establishment of a rule-like presumption that an ad is a functional equivalent of express advocacy only if the ad is susceptible of no reasonable interpretation other than as an appeal to vote for or against a candidate. And then in Citizens United, it was a rule-like determination that as a matter of law, independent expenditures do not corrupt or create the appearance of corruption. This rule-like determination ultimately became the basis of the Supreme Court's summary reversal of the Montana Supreme Court decision upholding a Montana campaign finance law without any review of the facts. Now, the new Supreme Court may jettison this new chilling effect concern. Because of its technical nature, it lacks political salience, and rejecting it might not impose a legitimacy cost that reversing other constitutional determinations might raise. But being true to the panelist's calls, I think there might be a path forward for a campaign finance standard that involves the consideration of facts that will ameliorate this new chilling effect concern. And this requires a shift to our focus to another institution, away from courts that are, for which it's costly and time-consuming to engage in litigation over matters, to administrative agencies that perhaps can be responsible for applying campaign finance standards. Arguably, the FEC has an expeditious and a cheap mechanism for resolving campaign finance disputes using fact-based standards, the advisory opinion process. However, it lacks the resources and the capacity to transform this advisory opinion process to an adjudicatory process that could efficiently and cheaply resolve such disputes.
Time.
Gotcha. But even aside from the absence of an adjudicatory arm in the FEC, the agency is unlikely in its current form to garner the trust and deference of the court to make such constitution-based determinations. And what will be needed is not only a shift and redesign of the agency to ensure that it's impartial, it can function properly, and that it can independently consider these disputes, but also the political will from a president that will place campaign finance reform at the top of the agenda, and that campaign finance reform includes the reform of the agency. And it's this agency that can allow us to evolve to a campaign finance standard-based approach that will allow for the resolution of campaign finance disputes that are not in a way that's not overbroad or under-inclusive. Thank you very much.
Thank you. Thank you, Professor Ross. Our next speaker is Professor Kate Shaw.
Okay, so I'm going to spend some time talking about campaign finance disclosure. I think in discussions of reform like the one that we are having today, there is a tendency to do two things with respect to disclosure. One is to take it for granted, that is to take its constitutionality for granted, right? To assume that it is on sound constitutional footing right now, at least disclosure of core activities like contributions to campaigns and PACs. And to not, so that's one, sort of to assume it's safe and to focus our energy on kind of harder and more pressing legal and constitutional questions. And then two, to not take the potential of disclosure, both as a mechanism of accountability and then maybe just kind of more broadly as a regulatory tool, sufficiently seriously. Because time is short, I'm going to mostly focus on the first of these, but we can certainly get into the second as well. Look, so I think advocates tend to be quite sanguine about the status, the constitutionality of disclosure, because on their face, the Supreme Court's most recent statements about disclosure don't seem to leave a whole lot of doubt about its constitutionality, at least in general terms, right? So take Citizens United, which also contained a challenge to federal law's disclosure and disclaimer requirements, and I'll just say I'll use disclosure to refer to both disclosure and disclaimer. Right, so there was an argument which was prominent in the briefing the first time Citizens United was heard, but sort of relegated to secondary status the second time, which was that the requirements represented compelled speech wasn't justified by sufficiently compelling government interests. And part 4 of the opinion, this tiny little piece of the overall discussion, totally rejects these arguments and along the way makes some pretty sweeping statements about, both descriptive and normative statements, I think, about disclosure's goals and its actual operation. So statements like transparency enables the electorate to make informed decisions, give proper weight to different speakers and messages, can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable. The First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of corporate entities in a proper way. Right, so strong statements and a clear suggestion that disclosure furthers some pretty compelling democratic values. The McCutcheon court said some similar things about disclosure in the course of invalidating the aggregate contribution limits, although there had been no direct challenge to the disclosure requirement. So this discussion was essentially in the course of offering the existence of what the court viewed as a far less restrictive alternative to the aggregate limits. But similar statements, right? Government interest in providing the electorate with information about the sources of election-related spending, and then this sort of with modern technology, disclosure offers a particularly effective means of arming the voting public with information that it minimizes the potential for abuse of the campaign finance system, et cetera. And then the third case, I think, in the sort of the trio of recent cases that address disclosure, Doe versus Reed, like Citizens United, a 2010 case, and not a campaign finance case, right, but a case about the applicability of a state public records law to referendum petitions and the signatories on those petitions. But there's a challenge to the compelled disclosure of the names by both the referendum sponsor and some of the signatories. And the court rejects that challenge. Justice Scalia, in particular, takes this very strong pro-disclosure position, writing in a concurrence that requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed, right? So some of the strongest language about the sort of values that disclosure advances. So all of this does seem like good news if you favor disclosure, or if you favor regulation, and even if you're not wild about disclosure, but do believe it's better than a thoroughly unregulated landscape. And I should say the court has been careful to note whenever it encounters direct challenges to disclosure or to disclosure requirements that it remains open to and indeed has sustained as applied challenges to disclosure requirements, either where there's a real possibility of threats or harassment or reprisal, or where the informational interest, and this mostly happens in the lower courts, but the interest in the identities of a particular group's donors, say, is very slight. So we're talking about very small groups that spend, quantities in the thousands of dollars. A number of lower courts have sustained those kinds of as-applied challenges to compulsory disclosure requirements in state systems. In general, though, the operating assumption is that all this is very safe. But I actually think it's a mistake to assume that disclosure, even of the kinds of core activities that I referenced earlier, is absolutely unassailable. And so I want to strike a cautionary note, and I think we need to be cautious for a couple of different reasons. One, I think, has to do with pairing and presentation. So when disclosure questions come before the Supreme Court in the campaign finance context, now that's not true in Doe, but Doe wasn't a campaign finance case, they come paired with more substantive regulations of money in politics. And I think that this pairing exerts a particular force on the way the court approaches disclosure questions, right? So both approving disclosure emboldens the court to invalidate other kinds of more sweeping regulations, and then the existence of these other regulations makes disclosure feel far less intrusive. So I don't think we should assume that the results would be identical in these cases if disclosure were confronted on its own. To the sort of brevity of treatment, so the Section 4 of the Citizens United opinion, which I reference, is this very, very small piece of the overall discussion. It's not a particularly developed argument in the briefing or in the court's discussion, and I think having, the sort of brevity of treatment, I think, means that there is somewhat less to the court's approval than meets the eye. I'll say more about that in a minute. And then the third is just the kind of dynamic and fluid nature of the law in this area, right? So folks who practice law here, and many folks in the room have been doing this for a lot longer than I have, know that the winds can shift quickly, right, in this area. So I don't think that approval, even by an 8-1 vote, which is the case in Citizens United and probably McCutcheon as well, necessarily sort of insulates from kind of an imminent constitutional attack, even the sorts of, like I said, core federal regulations, say, of kind of core activities like contributions to campaigns and PACs. So the fact that there, both brevity and, kind of the sort of shifting winds, right? So the aggregate limit in McCutcheon had, been, the constitutionality of it had been affirmed in Buckley. That fact, right, didn't give the court much pause. And in part, the court said in McCutcheon, the parties didn't really focus on it in Buckley, and it was it was one paragraph of a very long opinion. And I don't think it's impossible to see the same thing being said down the road about the disclosure discussion in Citizens United. It was a secondary issue, it was a short discussion, and we didn't give it the focus that it deserved, and sort of now turning our attention to it, we find it more troubling than we previously did. And you sort of have seen that similar kind of change in course happen in other spheres as well. And then maybe the fourth reason that I think some caution is warranted is that maybe the support is not as overwhelming as the sort of 8-1 vote in Citizens United for the disclosure provisions would suggest. And I think in part because, so Doe, right, remember, which is the case that is about disclosure standing alone, is a much more fractured opinion, right? So you have Justice Thomas, who says is consistent in this point, says that the law clearly does violate the First Amendment. But Justice Alito expresses real concerns about it. Even Justice Breyer says there are compelling interests on both sides of the case. So Scalia's statement is the strongest here. So his loss actually could conceivably cut in a different direction in the disclosure realm, potentially, than it does elsewhere. So if the recent blessings are not enough to give us comfort that disclosure writ large is safe, what are the sort of prescriptions for making sure that it does stay safe? So one, I would say, goes to the kind of framing and careful identifications of the interests involved in disclosure. So I think this is an area in which framing matters a great deal, and how we describe the work that disclosure provisions do, right, what constitutional values they advance, can have potentially real impact on outcomes. And I mean sort of focusing on these interests in a lot of different fora, right? In legislatures, so I don't think there's a lot of, although there certainly were attempts to do new regulation, federal legislation on disclosure through the multiple iterations of the Disclose Act. States have, with slightly more success, regulated on matters of disclosure. So I think speaking in the context of the legislative process about the sorts of values that disclosure provisions advance kind of that's one forum in which I think it's really important to sort of be specific about these interests, but also in public debates and also in litigation in defending these laws. I think disclosure opponents have very clearly articulated the specific values that disclosure threatens, right? They most sound in First Amendment values, although they're slightly different than the First Amendment values that are the sort of asserted in challenging other kinds of campaign finance regulations, right? So a right against government-compelled speech, individual privacy, associational privacy, maybe some sort of right to anonymous speech, maybe something like political privacy, sort of all, but mostly sort of sounding in the First Amendment. And I think that the interests that it advances have not been identified with with analogous specificity. So the court has made clear, as I said in some of the language in these cases, that disclosure furthers important values, but I do think that the content of those values has been somewhat underdeveloped. And in part because I think the larger community, like the court in these cases, has been largely focused on other kinds of more substantive regulations. And I should say that our commentators, Richard and Michael and others, have done great work on disclosure and theorizing it. But the project, I think, of actually building out and developing a set of arguments for the interest that disclosure serves seems to be a critical one. And I think even in the sort of post-Citizens United landscape, although in many ways it is one of the last big things standing, I don't think that we have sort of turned our attention with sufficient focus to doing that. So I think it could take a couple of different forms. I think one is sort of just building out and further developing the existing interest that the court has identified in disclosure, an informational interest, right, in an informed public, an anti-corruption interest. I think those two are not as neatly separable, maybe, as the court sort of suggests they are, right? So providing information to the electorate that then allows it to sort of hold accountable politicians for potentially acting at the behest of donors as opposed to constituents more broadly. Those things have elements of both an informational and an anti-corruption interest. So one is sort of further elaborating on how all of this operates, and I think that's both a theoretical and an empirical project. So sort of to echo some of the comments in the first panel, while I think it's been both somewhat theoretically underdeveloped, I think there is a striking lack of empirical work on how disclosure operates, right? I think that actually experimental studies, and sort of I need to hold myself, I have a social scientist co-author in one paper, and we've been talking about doing it. I think now I'm convincing myself that we actually really need to sort of do this, because I don't think it's that difficult to design studies that sort of provide information and ask individuals to sort of, explain. There are some studies out there that do that, but I think very few that sort of say if you give people information, do they understand better sort of how to place a candidate on an ideological spectrum, say if they know the sources of a candidate's funding. And I think there are other kind of interesting ways you could do that, and I just don't think it's been done much. And I think that if and when the court again confronts, say, standing alone questions about the constitutionality of disclosure, a really robust record that does contain strong empirical research about how, if at all, a disclosure impacts voter behavior, I think is critical. And it's possible that experimental studies like this won't pan out, right? So that maybe disclosure does not have the actual impact that we think it does. But I think that actually if you could sort of clearly establish that, you could direct reform energies elsewhere, and that would be a really constructive result as well. So I think you have to be open to that possibility, again, sort of echoing what was said in the first panel, if you're going to embark on a serious sort of empirical project. And so that all sort of falls under the rubric of further developing kind of the existing interests. And then the last thing I'll say, and I see I'm out of time, is just the identification of different and new interests in disclosure, right? So the majority in Doe versus Reed identifies an electoral integrity interest, which is not an interest that we have really seen in the campaign, the candidate campaign context. And perhaps there's a way to think about that interest doing productive work here. Nick Stephanopoulos' interest, the identification of the alignment interest, I think sort of disclosure could sort of do interesting work in. So I will stop there. Thanks everyone for your time.
Thank you, Professor Shaw. Our next speaker is Stephen Spaulding of Common Cause.
Good morning, everybody. And thank you, Free Speech for People. Thank you, Seton Hall, for hosting us today. I'm here on behalf of Common Cause wearing an advocacy cap. I'm the Senior Policy Counsel at Common Cause, which is an organization, if you're not familiar with it, with over 400,000 members throughout the country, 35 state organizations, many of which have a staff and boots on the ground that are working on these proposals and wrestling with them every day, working with administrative agencies, working with elected officials, and working through all of the problems that we're talking about. And so the paper that I'm working on with the president of our organization, Miles Rappaport, is really aimed at talking to a lay audience and aimed at the folks across the country that are scratching their heads and are fully cognizant of the problem of the power that money plays in politics. I think that first panel was terrific. And my message here, first of all, is that from an advocacy perspective that's concerned about the influence of money, we've won the debate. Republicans, independents, Democrats across the country understand what's going on and understand that their elected officials are not being responsive to the needs that they have and that they go to the polls to promote. So what we're working on with a coalition of organizations, including many in this room, is what we've called the 21st Century Democracy Agenda, the Fighting Big Money, Empowering People Democracy Agenda, that really has 5 pillars of democracy and then a variety of different solutions, policy solutions that fit within each pillar. And the pillars are, one, we need a democracy where everyone participates, where everyone's voice is heard, where everyone knows who's trying to influence our views and our representatives, where everyone plays by fair common sense rules, and where everyone is held accountable. And within those 5 pillars, we have a variety of policies that I'm going to walk through now that I think many are familiar with, and I'll be at the 30,000-foot level here. But I think it's also important to realize, at least from my perspective, that there is no single solution. There's not a single solution within our campaign finance system, but it also requires looking at gerrymandering. It also requires looking at our election administration and our voting laws. So there are multiple facets of restoring a government that is responsive to our needs. But back to the money and politics issues, first, the first plank, everyone participates. Here we're talking about small donor public financing, and I know we're going to hear more about it today. We're going to hear more about it from Adam. We're going to hear about all the different ways that we can empower voters and empower voters and make their voices heard in part of the process, and lower the barriers to entry for people that want to run for office and lack the connections and lack the resources to do so on their own, like Mr. Trump. Once those policies are in place, we hope that candidates will spend more time talking to their voters and less time talking to wealthy donors and lobbyists. We hope that it will increase the number of donors, actually, but that money will be coming from a more representative segment of the population. We hope that it will lead toward more diverse legislatures that look like America, and ultimately we hope that it results in policies that are responsive, again, to the people. So there are bills in Congress pending right now, the Government by the People Act by Mr. Sarbanes in the House, the Fair Elections Now Act in the Senate, that we are working to pass. We at Common Cause and worked with other organizations, of course, in setting up small donor public financing programs that have been quite successful in terms of the number of candidates that are running under the program in Maine, in Connecticut. Certainly at the municipal level, we are looking at programs in Chicago. So there are policies that have been in place. There are policies that need to be updated, just as the voters in Maine did in November. And moving forward, we will continue to finesse those policies in the wake of our current system with unlimited independent expenditures. Everyone's voice is heard. Here we are endorsing the policy of contribution limits, common sense, reasonable contribution limits that again ensure that more voices are heard by the people. Third, what Professor Shaw touched on, where everyone deserves to know who influences our views and representatives. I lean very heavily on a lot of that language from Citizens United with 8 justices, assuming when they open the floodgates that voters and shareholders would be able to hold corporations accountable. In McCutcheon, I think the language is at the click of a mouse, and I think they actually cite the Center for Responsive Politics in that decision as that data being available. Well, it is available thanks to Open Secrets, but a lot of that is still secret. A third of the outside money came from undisclosed sources. So the law, our policies, and our disclosure systems have not caught up to where the Supreme Court assumed they would be. So of course there's the Disclose Act, which has been through multiple iterations in Congress. It passed the House in 2010. It actually got 59 votes for cloture in the United States Senate, but because of the filibuster rule, 41 senators can defeat 59 senators, and it was dead. And that there have been multiple votes. Every single time that the Disclose Act has been put on the Senate floor, by the way, it has received a majority of senators in support of the bill, but because of the filibuster rule, it hasn't moved forward. Sidebar, I think Senate rules are another issue that we need to repair in our democracy if we're going to get back to a responsive government. But while Congress is gridlocked, there are efforts underway at the state level. Massachusetts passed a disclosure bill last year that actually requires the top 5 donors, the top 5 contributors to be disclosed in ads. We know that in California there are disclosure bills that are moving forward, and in Rhode Island they actually passed a disclose-like, and when I say disclose-like I'm referring to the federal bill, a disclose-like bill that actually gets to what we've called covered transfers, which solves the problem of money flowing through multiple entities. And when when a voter wants to see who's giving to this organization, they just find out that Americans for America gave to Americans for Apple Pie, gave to Americans for Purple Mountain Majesties, and never gets to the underlying source of the money. So that is what the Disclose Act tries to do, and that's what the legislation, the law in Rhode Island endeavors to do. But federally, back to the federal level, we think that there are agencies that can also move forward on filling in the gaps that the Supreme Court assumed were in place when it decided Citizens United and McCutcheon. For example, the Internal Revenue Service and the Department of Treasury could reconcile the rules that have been in place since 1959 governing social welfare organizations. Social welfare organizations, 501c4s, have recently become the vehicle of choice for donors that would like to hide their identity or political operatives that want to provide donors an opportunity to hide their identity. We know that hundreds of millions of dollars have flowed through these 501c4 organizations because tax lawyers and other operatives have taken advantage of a discrepancy between the law the tax code, which says that social welfare organizations must be organized exclusively for the promotion of social welfare, which excludes campaign intervention, and the regulations, which say that exclusively engaged in social welfare means that the organization is primarily engaged in the promotion of social welfare, which means that people have spent up to 50% of their resources and more on political spending. So we know that we need to draw brighter lines from our view as to what constitutes political activity and also how much political activity these organizations should do before setting up an entity under Section 527 that would require donor disclosure. So the IRS and the Treasury Department have a role to play there. We also think that the SEC, the Securities and Exchange Commission, could promulgate a rule requiring public companies to disclose their political spending to shareholders. We think that's common sense. There's been over 1 million comments that have been filed at the SEC, although we haven't seen action there. The Federal Communications Commission, a member of our staff, Michael Copps, former acting chairman of the FCC and a commissioner on the FCC, has been leading a push called the Your Right to Know campaign. Under Section 317 of the Telecommunications Act, it says that broadcasters need to disclose the true identity of the sponsors. And we think that that provides the FCC with authority to promulgate rules to put in-ad disclosure into campaign ads. And I've ignored, of course, the FEC, which the Federal Election Commission, given that it's stuck in 3-3 gridlock, but we think the FEC also needs to update its disclosure rules as well. So that's all within the context of disclosure right now and filling in the gaps. We think there are administrative solutions and legislative solutions moving forward. Of course, altering the campaign jurisprudence is going to, again, require a Senate that works. It's going to require a nominations process where Justice Scalia's replacement will be in place. But hopefully, once we have 5 justices, we too are exploring ways to elevate other justifications beyond quid pro quo corruption that can uphold our campaign finance laws, such as those that Justice Stevens put forward in testimony before the Senate Rules Committee in 2013 or 2014. Leveling the playing field. Something that litigants are well acquainted with are page limits on briefs, on fairness in the adversarial process, which is also part of our campaigns and elections, and perhaps is another justification that should go into the ether. Finally, enforcement. These laws are only as good as they are enforced. We do not have a Federal Election Commission that is enforcing the law. Its former chair, Ann Ravel, said that in the New York Times, the FEC is worse than dysfunctional. There are 3 Republican commissioners that are ideologically opposed to campaign finance laws, and they just refuse to enforce them. So we do endorse at Common Cause restructuring, as Professor Ross mentioned, restructuring the Federal Election Commission so that it can act. There are a variety of models. One would put in place a chair who might serve for a decade and would have a Republican and Democratic appointee as well, perhaps with administrative law judges, so that it could actually assess penalties when necessary. Right now, the only power the FEC has is to ask folks to enter into conciliation agreements and then take them to court. There is a bill that was just introduced in the Senate by Senator Tom Udall of New Mexico that would reform the FEC. We expect a companion bill to be introduced in the House probably next week. We also have a bipartisan bill in the House that would also reform the way that the FEC is set up so that it is no longer just a watchdog with no bite. So thank you very much, and I look forward to the conversation.
Thank you, Stephen. Our next speaker is Adam Liaz of Demos.
Good morning, everybody. Hi. My name is Adam Liaz. I do work for Demos. For those who don't know, Demos is a public policy organization working for an America where we all have an equal say in our democracy and an equal chance in our economy. So we're talking here about the equal say part. But at Demos, broadly speaking, we really, I think, share the vision that Professor Kuhner laid out about the maybe dramatic but absolutely accurate view that we are caught essentially in a vicious cycle right now, where the wealthy are able to use their economic might to purchase political power, write rules that keep themselves wealthy, and leave the rest of us struggling to stay afloat, and often leave people of color outside that process entirely. So we work at the intersection between political equality, economic opportunity, and racial equity at Demos. And I'm particularly thrilled to be here. I cut my teeth as a campaign finance advocate back in the day when I was John Bonifaz's client, suing against the doubling of the hard money contribution limits in the McCain-Feingold law. And I'm also thrilled to be joined here by Mark Alexander, a Demos board member. So with that, I will say that I'm going to describe, so if you haven't had your nerd hat on yet, this is the time to really get it fitted, because I'm going to go not from the 30,000 foot level, but kind of into the weeds to describe a particular kind of public financing system that we at Demos have been working to figure out. As context, I want to talk a little bit about the problem that we are looking to solve with this system. So as everyone knows here, and as we've been discussing, the court has said time and again that only fighting corruption is a problem that we are allowed to target and solve. And certainly a public financing system does that by causing candidates to be far less dependent upon wealthy donors. But I am also deeply concerned with the problem of equal voice in our political system, with the problem of barrier to entry, the fact that for an ordinary American to get up and make the rational decision to run for office is very difficult, when in order to match the median amount of money raised by a Senate candidate in 2014, that person would have to raise $3,300 every single day, not for 2 years, but for 6 years in a Senate cycle. So if you got started a little bit late in the game, well, plenty early in the game, 3 years before your race, you're having to raise $6,600 every single day. Well, where are you going to get that money, right? So this is a problem of, there's many facets of this problem as folks have talked about, and I think we need to attack them all. So there have historically been two basic money and politics public financing models that have emerged over the years. There was originally a model that which many folks call the clean elections model. It's a grant-based system where you raise a certain number of qualifying contributions that are very small, often $5, and then you get a whole grant, and that's all you're allowed to spend, and your fundraising is done. In recent years, partially due to the Supreme Court opening up the outside money flood, is that we've moved towards matching systems where you continue to raise funds and you get them matched at a certain ratio. The Government by the People Act, which Steve mentioned, is the leading bill in Congress, which gives a 6-to-1 match or even a 9-to-1 match if you meet certain conditions. And then we have an idea that's been kicking around for some time, but we finally have a policy in process, which is the idea of a voucher, a democracy coupon. I particularly love this idea because it's decentralized public financing. And it doesn't require you to actually put out, have the resources to put out money in the first place. And so potentially it does the best job at engaging folks who may not have the disposable income to even give 20 bucks. And that's going to be experimented with in Seattle, which is very exciting. So at Demos, what we've been thinking about is, how can we take the best elements of each of these programs and put them together in a way that would solve both the corruption problem and go towards it, but then also look to solve some of these broader problems. And so we came up with a mixed design, which is what my sort of abstract is about, which I'll try to describe briefly here. The heart of the system is a voucher. You give everyone across the country a $150 voucher or coupon. They can give that to candidates, parties, or political action committees, and this is something that where we depart from the Seattle model. I think it's great that the Sierra Club and the NRA can actually go out and knock on doors and convince people to give them their voucher, and to say, you may not be sure about the candidates in your district, but trust us, we have your interest at heart. You know us. We're going to vote. We're going to give that money in the most efficient way to an environmental candidate, a gun, whatever your political views may be. Then the amount of money that we chose for the voucher, this is sort of probably too deep in the weeds, but the idea is to ensure that there's enough funding in the system, especially with an eye towards challengers. So earlier we talked about the court's concern about incumbency protection. Well, the idea is to get enough money in the system that people will be able to reach that threshold that they need in order to become competitive, but also keep an eye on the cost in the public purse, and I'll return to that in a few minutes. And then also we had an eye towards the fact that the dynamics of a voucher system at the national level would necessarily be bit different than at the state and local level. And so we had to think, well, how would you get vouchers to the people? And the initial thought was, well, the FEC would do it. But in addition to other problems with the FEC, it turns out there is no national database of where everyone lives. And we don't really think we want to create one for this purpose, for privacy concerns. So we're actually recommending a more decentralized state-based system where the FEC would give bundled vouchers, which would mostly be codes, to the states, and would give grants to the states then to distribute them out using information the states, broadly speaking, already have about people through the DMV, public assistance agencies, et cetera. So keep it down at the state level is our main strategy. So then we are going to put a match on top of that voucher. So what we're recommending is a 3-to-1 match on top of voucher contributions. And you might say, well, why would you match a voucher contribution? It's already public funds. Why not just make the voucher larger? Well, the purpose of the match is sort of twofold. One is it's to, again, be able to put more resources into the system so you're ensuring the viability of candidates. But it's also to create incentives. So the match only goes to contributions to in-district candidates or I think some political parties we have also. And so the idea is that in this system of all this robust outside funding, we think that candidates and parties play an important role. So we want to make sure that they have enough funding and that it's robust. And then on top of that, we layered in some micro grants to help people get started. And again, this is also an idea of fighting incumbency by helping people get into the system and be more fluid. In our system, now this is supposed to be all within the current jurisprudence. There is one aspect that would push that envelope, which is that we'd only give those micro grants to challengers. We'd also give a temporary match on private contributions only to challengers. That, I think, might not survive currently, but we might push the envelope on that. But it would be an interesting case to bring to the court because they profess to be so concerned about incumbency. And so obviously you're unlikely to get that through Congress, but you might get it on the ballot. So I think it would be kind of an interesting provision. So any system of public funding depends upon the surrounding system of contribution limits and other campaign finance laws, right? So one of the reasons why Citizens United and others has become such a challenge and a problem is that there has to be sort of a basic scaffolding around these public financing systems to help them effectively make sure that people have the incentive to participate, et cetera. And so we think that the limits are important, and the system that we are designing, we're designing in a way that could actually be compatible with some fairly aggressive limits. So the idea is to get enough public funding into the system so that if you actually, in a future regime with a different court, wanted to actually ramp down the limits significantly, you'd have the ability to do that without entrenching incumbents because there'd be enough resources flowing into the system. But we haven't specified at this point, what those limits would be in terms of the surrounding the public financing system. And so in the meantime, what we would hope to accomplish with this system is sort of what Professors Ackerman and Ayers talked about in their book about this, which is sort of flooding the system with small dollars, and that on its own should dramatically reduce the impact of larger contributors. So with that in mind, let's talk a little bit about how much all this would cost and the money. So obviously the costs would depend highly on the voucher uptake rate, which is something that's very difficult to predict and to know. We ran a large number of situations depending upon different assumptions, and we took sort of medians, but we ended up deciding that if we used an initial uptake rate of around 3%, which is greater than the current assumption. It's hard also to get an existing rate for how many people contribute because the ones below $200 you don't have disclosed data for always. So, but we gave it a bump to 3%, and then we gave an upper end estimate of 11% after essentially 5 election cycles. If this program were really to catch on and people started to learn about it and to use it, we get to 11%. And with that, we calculated a total cost of $7 billion in the initial cycle and $13 billion per cycle over the first 10 years. Now, I'd say this strikes me as a huge bargain for potentially taking back our democracy. It is a fraction of 1% of our national budget. It is far less than we spend on special interest boondoggles. So I think when we talk about cost in this element, broadly speaking, we're talking about rounding errors, and it's not something that should hold us back from pursuing a system like this. But if the voucher rate does go up, then the cost will go up significantly. So we've actually built in some ramp down provisions so that we can make sure that we're controlling the costs along the way. And it's also possible that the public support for the program would become reduced if the perception builds that we're spending billions and billions of public dollars on our elections. And a lot of people already think there's too much money in politics, which, sidebar, I don't think that's the correct definition of the problem. I think it matters where it comes from, not the amount. But a lot of people do have the perception there's too much money, and so we don't want to, we could risk losing support for the system by adding to that perception. So I'll just close with one thought, which is that I actually think there's a scenario in which flooding our elections with a lot of small dollar money could have a positive externality, which is that I do think that there is some upper level limit on how much you can spend on elections and have it be useful. There's certainly diminishing returns, and I think there's some upper level limit in which an additional TV ad, even additional voter contact, will either backfire or have no effect. If we get to that limit and we have a huge amount of public money into our elections, I think what we might see happening is the relatively egalitarian political or electoral sphere start to perhaps subsidize the highly inegalitarian civic infrastructure sphere, where right now we have no actual values of equality taking place with funding of C4s, funding of even foundation money, all these kinds of things that are coming into our civic infrastructure are not really based and tied to these values, which that may be fine, but it might be a positive externality to get some of this small donor money actually going into that outer circle and subsidizing that. So I'll stop there.
Thank you, Adam. So now we have two discussants, Professor Michael Gilbert.
Okay, good. Thanks. Just briefly, thanks to Gene and others for including me, and thanks to all the panelists for these interesting presentations. I enjoyed them very much. I learned from them. I just want to say on the front end, I, of course, share the goal of everyone in the room of improving representation and reducing corruption, making democracy better, and I very much have this perception that less money in politics would be a good idea. Now, having said that, I'm an academic, which is a fancy synonym for a professional critic. And I'm also of the view that this is complicated and that the opportunities for reform are not unending, they're quite narrow. So when a window opens up, we have to be sure that what we do with it is effective and it achieves what we actually want to achieve. So it's in that spirit that I'm going to offer some, I hope, constructive comments on the presentations and ideas. So I'll start with Bertrand's idea. As I understand it, Bertrand is arguing in favor of a kind of case-by-case as opposed to bright-line rule approach to regulating independent expenditures. So the court has the bright-line approach. Bertrand's suggesting if you do it case-by-case, maybe you actually could, within existing jurisprudence, regulate some of these independent expenditures. I'm sympathetic to the idea. If I have to pick a team, I'm kind of a standards rather than a rules guy. But I see potential problems. One of which is, how do you sort out whether an expenditure is likely to cause corruption on the front end? I think that's what, through the advisory opinion, you're suggesting the FEC or possibly some other body would have to do. I mean, the typical sequence we imagine with a corrupting independent expenditure runs like this. The expenditure comes first, and then the corrupt, oh, sorry about that. I sound so loud up here. Okay, the typical sequence we imagine is the expenditure comes first, and then the corrupt acts comes after, right? It's a quid pro quo. So if you're asking for an assessment on the front end of whether this independent expenditure is going to cause corruption, you can't possibly know until you see what happens on the back end. I think the same potential problem arises with respect to the other related interest, which is the appearance of corruption. I don't know if this independent expenditure is likely to create an appearance of corruption. I kind of need to know what the public's going to think about it after it happens, which is just all to say that in practice it seems to me there's going to be a lot of relying on intuitions here that could be potentially problematic. On the other hand, I really like this suggestion with respect to one issue, and this is going to relate to Kate's paper, which is think about disclosure stuff and think about the argument about chilling. So Bertrand was referencing this. We don't want things to be over-inclusive. We don't want to chill what should be protected constitutional speech. Well, I'm going to focus now on disclosure. Do disclosure laws actually chill speech? We have no idea. Everybody understands the intuition, Right? There are some people out there who would speak, ooh, but if you have to make it public, now I'm reluctant, so I'm not going to speak at all. Probably that happens to some people, but I don't know how many. Nobody does. We don't know how much speech is chilled. And on the other hand, just as disclosure might chill the speech of some, it simultaneously might promote speech by others. So I didn't know where these candidates stood without disclosure. I don't know what their platforms are, and as a consequence, I'm not inclined to give to anybody. But as soon as you disclose, now I know something about them. I might realize that I really like this one and really hate that one, and all of a sudden I might spend when I otherwise wouldn't. So disclosure, for example, might promote speech rather than chill it, and a case-by-case approach to all this stuff could help you potentially suss that out. So let me focus directly on Kate's paper now. I very much agree that we need to spend time thinking and buttressing the constitutionality of disclosure. And that's because I'm of mixed minds on this. My instinct is that disclosure and transparency has to be a good idea. How could it make things worse? But when I sit down and try to think through the logic of this, actually I'm always left a little conflicted. So let's just focus, I don't have much time, I'll just focus on one piece of this. As Kate was suggesting, the principal argument in favor, in fact the only constitutional argument in favor or state's interest argument in Citizens United to uphold the constitutionality of disclosure is the so-called informational interest. So the idea here is if you tell voters who supports these candidates, now voters have some information they otherwise would lack, and they can cast a more coherent, intelligible vote. Okay. I understand that piece of it, but come back to this chilling effect idea. Suppose that everybody seems to assume disclosure chills speech, and let's suppose for the present that that's true. When you require disclosure, speech is chilled. Well, now we have two pieces to a puzzle that suggest that the informational effect of disclosure is actually up in the air. So just picture two worlds. In the first world, you have lots of political speech, but no disclosure. So there's lots of speech, and maybe I learned something from some of it, but I don't know who's behind any of it. In the second world, you have disclosure, so I know who's responsible for the speech, but because of the chilling effect, there's less of it. So are voters more informed in a world with a little bit of speech and you know where all of it comes from, or a world where there's lots of speech and you don't know where any of it comes from? We have no idea. We don't know the answer to that question. And whatever the answer is, it might be case by case. So this is not meant to say that I think disclosure is a bad idea. Quite the opposite. I think we need to really think hard about this. The informational interest may not sustain it, and we need empirical studies to work this through and actually learn something concrete. The time goes so fast. Okay, so I'm going to just combine a couple of comments on Stephen and Adam's papers, and then I'll leave it at that. Stephen gave us lots of steps to pursue, probably simultaneously, to reduce the influence of money in politics, including some disclosure stuff. Maybe some of my comments I already made are relevant to that, and also public financing. This relates to Adam's proposal for a voucher system. With respect to the vouchers, I share the intuition that was developed in Ackerman and Ayer's book, which is that if you just flood the system with small donations from lots and lots of people, the need for any particular large donation shrinks, and as a consequence, we don't feel so bound to these people. On the other hand, I just wonder what voters would actually do with these vouchers. So one way to think about it is if voters just participated and held officials who we perceive to be corrupt accountable on the back end, we wouldn't be so worried about all this money. But many of us believe they don't actually do that, right? Participation rates are low. We don't kick the bums out of office. Okay, well, the same voters who fail to do that are going to be the voters to whom we're giving vouchers. So if we don't keep them accountable on the back end, why do we think we're going to do a better job of keeping them accountable on the front end, especially when it's not even our money we're spending? What do I care? Take the voucher. For some people, I think it'll work that way. If you want a concrete example, how many vouchers do you think Donald Trump would have gotten so far? I suspect the answer is lots and lots and lots. And depending on your views, you might think, boy, that's not helping with the problem of wealth and corruption and plutocracy and so forth and so on. Which is all to say that I think, two final points, I think it's fabulous that you are piloting some of these programs in smaller markets because we need to see if they work. Again, the window's narrow. Before we if the window arises at all or opens up, before we try to implement something like this on a national level, let's see if the thing works. We don't know. It might backfire. And then the last point I'll just make is, with respect to all this public financing stuff, I've got to think changing the jurisprudence is a key step. As long as independent expenditures are in the picture, and if you share my view that the court's claim in Citizens United that they don't cause corruption is just self-evidently absurd, I just want to spend a minute on that, actually. Think about what you would need to know to draw the conclusion confidently that independent expenditures don't cause corruption. How could you possibly know that no such expenditure had ever before caused a single corrupt act or will in the future? That's ridiculous. Okay, well, it seems to me if independent expenditures do corrupt, and as long as independent expenditures have to be unregulated because of Citizens United and other cases, then it's not clear to me that all the public financing in the world is going to make a big difference. So I think that has to be part of the strategy. I'll stop there.
Thank you. And Professor Richard Berfault.
Great. Since I think I'm the person between you and lunch, or you and you, right? Between you and you, I'll be brief, and I'll more or less follow Michael's model of sort of going down the line here. Bertrand puts his finger on two extremely difficult questions in our system. One is the problem of line drawing. What can we regulate? I think of it as the problem of distinguishing between elections and politics, which you may say is impossible, but that's the problem. It is extremely difficult to regulate political activity generally. That is sometimes the core form of First Amendment activity. The court has, however, carved out an exception for elections. And we have an extensive amount of election regulation, disclosure for contributions, and for a time, expenditures, at least by corporations. So that the question of drawing lines between elections and politics is, in some sense, a central issue. Right now, it's more relevant to disclosure, who's subject to disclosure, but it could become relevant again to expenditures. The other problem he puts his finger on is administration and enforcement, and several people on the panel have referred to the dysfunctionality of the FEC, and it's broader than that. Not just at the federal level, but at the state levels as well, state and local. All forms of effective election administration, all election laws, all campaign finance laws, require an administrative system that walks the fine line between effective without being unduly partisan or tyrannical. The federal level, we've gone totally towards dysfunctional. We need to have a system which is more effective, but yet not one dominated by the party in power, not one that is unduly abrupt or somehow suffocates political activity. It's a very difficult line to draw. On the elections politics distinction, Bertrand sort of focuses on the movement towards a more case-by-case analysis. And there I think I have to disagree. I think that, in terms of the difficulties of overbreadth versus vagueness, he wants to make the law potentially broader to pick up the situations we want to pick up and to respect the values on both sides of the line, which I agree with completely. But case-specific analysis is going to be very vague, and it does have the sense of uncertainty, and it's going to turn a lot on the vicissitudes and the variabilities of who the administrators are. He sort of addresses that problem through decentralization, which I think is very clever, of saying, well, if we can't fix the FEC at the national level, then we could break it up, in effect have little regional bodies which might be more decisively organized. I'm not sure that works. I mean, I don't know how it works with the the presidential election. It might work for Senate or House elections where you have in effect the circuit, the Seventh Circuit the Seventh Circuit FEC would address elections in Chicago. But I think it might not be acceptable to have a system where you have actually very different approaches to what constitutes electioneering in different parts of the country in national elections. So I think that I think this is one where the frame for this panel, which is accepting the current jurisprudence, doesn't quite work. And this is when we have to start pushing out the jurisprudence a little bit. And I think in terms of deciding what constitutes a constitutionally acceptable definition of election-related, and I think this will relate to more that's going on today in this relatively uncertain time of constitutional status. This is one where I think I wouldn't accept the frame. I'm intrigued about how to think about how to restructure the FEC, as several of the panelists have talked about. I think that is, constitutional doctrine is sexier, but in the end it's all going to turn, whatever the doctrine is and whatever the campaign finance system, the public funding system won't work without effective administrators. And delegating to the states, I don't know. I think about the Secretary of State of Ohio, Mr. Blackwell, in years gone by, or the current Secretary of State in Ohio, or my own beloved New York State Board of Elections, which is as dysfunctional as the federal FEC. So not criticizing it so much as continuing to scratch my head and saying the Achilles heel of almost all election regulation, if we ever get to having adopted election regulation, is figuring out the administrators. Turning to Kate, I'm not yet ready to view with alarm. I endorse entirely the view of let's know more. It's absolutely right. And let's bolster the case. Let's lock in the case for disclosure if there's a case to be made with real data. Who could disagree? I don't really think anybody really could disagree with that. I think it's right. I'm not yet ready to view with alarm. I think actually the doctrine is pretty solid here. There are two issues that probably this would be useful for. One, and I think I wrote something on this, I sort of sounded the alarm on this about 6 or 8 years ago, which is the way in which the notion of reprisal. Remember, the Supreme Court has said disclosure is generally fine except when there's a well-founded threat of harassment or reprisal from the disclosure. And there was a bit of a movement, and this is where I think the anti-regulation movement has gone. I mean, back in the 90s, the anti-regulation movement was deregulate and disclose. That was their alternative. Beginning in the late aughts and more so now, there's been the attack on disclosure because of the concern that disclosure is going to lead to certain kinds of boycotts. And this really grows out of the Proposition 8 experience in California, that the evil liberals, well-organized liberals will boycott, or the target of boycott in 2010. That the result of disclosure will be targeting campaign donors and campaign participants, and that will have the chilling effect. And that's what, in some sense, elicited Justice Scalia's famous home of the brave. So far, the courts have not bought that argument. But I think it would be useful to continue to have data to show both what is the reaction to disclosure, if any, and then it's a conceptual one, and what counts as illegitimate. When is a boycott of somebody a chilling effect, and when is a boycott a legitimate political response? I think we need to have that discussion going forward. The other thing, the area where I think it might, and this relates to something that Stephen pointed to with respect to the Massachusetts laws, is these so-called disclaimer laws, or I would call them attribution laws. The requirement, particularly for non-candidate, non-party groups, that they list their principal donors in their ads. The court did uphold that, in a sense, in Citizens United, but I actually think the case for that needs to be developed, because I'm not at all sure, both what value that has, especially if the big donors' names are not known to people, and does this begin to look at as a kind of public shaming. So I think that's also something where I think the research and the discussion would be useful to keep going forward. Given that I'm almost out of time, I think Stephen actually gave too much to talk about, so I'm going to say, no, I can't talk about it, and go directly to Adam. The one thing I want to raise, I've always been a big fan of public funding. I've been a little more skeptical about vouchers, but God bless the people of Seattle for adopting it. We'll see how it works. I do want to raise one particular question, and sort of the mantra in this room today has been equality, but of course, the political science literature in the last couple of years has moved on in some ways, or conjoined equality to polarization. And obviously, all the talk about gridlock and polarization and the nasty state of our national politics has been on polarization. There is a literature that suggests that the more we go to that small donors, and especially voucher users, and you basically expect that no more than 3% of the people will be voucher users, will be the most ideological, most polarized donors. And that it's the people who are most engaged and most committed who are going to use these. And I'm not saying that that's right, but that's an argument that's being raised in other and I think that needs to be addressed going forward. Is while as we move towards greater equality and reducing the role of big money, are we simultaneously locking in? I mean, the comments made about the Trump voters. Are we strengthening the Tea Party movement and its and the alternatives? And not just a right-wing thing, although I think it has been more a right-wing thing, and saying that this is going to actually contribute to the polarization of our politics by favoring that. And so I think it's something that needs to be addressed. And I mean, I think the literature on this is inconsistent as to whether small donors are more ideological or not. But I think in making the case for it, that's an argument that has to be prepared to parry. Final thing, and it's just sort of just I think there was actually an inconsistency, something that Adam and Michael said, and I want to put myself on the Adam side of the thing, which is there's no such thing as too much money. Or I don't believe that the level of money is the problem. The problem is where the money comes from and the division of the money. And I mean, I think Michael may have mentioned just in passing that one of the values of this would be to reduce the amount of money in politics. As all of the literature points out, we spend more money on toothpaste than we spend on politics. We spend more money on yogurt than we do on politics. I think the issues are always going to be where it comes from and how it's divided. I don't really care about the volume, and I think you're right to say that that's not an issue.
Great, thank you. Right, so why don't we'll have panelists answer in the context of questions, but let's open it up to see if there's any questions from the audience and other participants? Gene, go ahead, and then and Brent in the back. Go ahead.
So one thing on all of these reforms that I really want to push you guys on, and Adam's made me think about this. You know how Heather Griffin has this famous here to there thing. How would you implement this stuff? And when I listened to this is a question for everybody, right? It's really easy in the academies to say we should do this or we should do that. And then the conference concludes, and you get back on PAT train, you go back to New York, you go to the airport, you get back on, you fly to North Carolina, or whatever it is. And then you go to another conference, and you say, we should do this, or we should do that. And the whole problem in this is how you implement these things, right? The whole problem is how you get from the system we have today to the system that you want. And
Okay.
I see Steve's hand going up, so I know you've thought about it, but I mean, the question was, I started thinking about it in each panel, and then with Adam, I was really thinking about it, right? I mean, you're telling us about how much it costs, but how do we implement this kind of system? Where do we get it from? We have a collective action problem. I mean, Congress is polarized. They're not going to pass a law on this thing. So I just throw that out there because I think it's such an important question.
So
Okay, so go ahead.
One, I mean, from a legislative perspective,
Yeah.
you know, I've been thinking about this too, given that since I've been in D.C., I mean, Mitch McConnell has an iron grip on the Senate, I mean, in terms of what can get to the floor. You know, in Maine, the Clean Elections Program passed by voter initiative. BICRA, McCain-Feingold, the only way it got a House vote was because of the discharge petition. It was actually the last time that a discharge petition has been successfully used in the House. So that entailed getting a majority of members of Congress, both Republicans and Democrats, to sign a petition to bypass the committee process and to get a vote on the floor. So when some of these reforms have moved, it has not been through the traditional legislative process. It's been through the initiatives or the discharge petition. And so it hasn't flowed the way most of our laws, you know, are passed. That's just in terms of getting these, you know, policies in place, at least through Congress, and in some cases at the state level.
Adam, go ahead.
Yeah, I think there's two separate questions embedded in your question. There's the question of political will, and then there's the question of mechanics, right? So how do you pass it, and then how do you actually get it done, right? And so on the passing question, so Steve, Common Cause and Demos and a host of other organizations collaborated earlier this year on a report called Our Voices, Our Democracy, which highlights all of the moving campaigns in 2016 that are happening on the ground, largely in cities, some state ballot. I mean, the ballot is a huge tool for this. Municipalities are a huge tool of experimentation on this level. And so, as Richard said, we have Seattle, and that is my transition point, right, which is we have Seattle that's going to start to wrestle with some of these difficult questions. One of the questions that I didn't allude to is how do you get the vouchers to the people, right? And if you start with voter registration lists, you're replicating essentially an unequal system whereby people who have less wealth, people of color, are less likely to be registered. So we fought very hard to make sure that people who are eligible voters but are not registered are at least able to request a voucher even if they don't get one directly, right? So there are all kinds of very thorny questions buried in what sounds like a high-level policy design, and the answer is I think you have to kind of dig in, roll up your sleeve. First, you have to manage the political will, which I think is the far larger problem. Once you've got that, you got to dig in, you got to roll up your sleeves, you got to make mistakes, you got to iterate, you know. And I think this whole idea of pilot program. I mean, one idea that I've started floating on the Hill, if anyone is watching from the Hill, is let's get a pilot program that can take advantage of what Seattle's doing. Let's add a few other similar cities. Let's get some political sciences involved. Let's study the voucher uptake rates. Let's study the different methods of distribution. And let's start to iterate and actually figure out how we can best do these things.
But this is on the local level and national. I mean, are you saying that you want to test the system out on the local level without going national because that will doesn't exist?
Well, yes, the will for a national voucher system does not exist in this Congress. So yes, we have opportunities at the state and local level. We can learn lots of things so that when the political winds change and we have opportunity at the national level, we'll know more about how to implement it. Now, as I alluded to, there'll be unique challenges of doing it at the national level that we'll have to think really hard about. And then, you know, we should probably put one of the things that when we were designing this system, one of the things that we considered is trying to encourage Congress or some body to revisit things after 5 election cycles, because, you know, it will be to a certain extent imperfect, and we want to bake that in if possible.
Anyone else on the panel want to address?
Yeah, I'll just say something really shortly. Political will can often be generated through, you know, seeing the effects of how something works. And I think that, you know, sometimes lack of political will is often based on the unknown. We don't know how it's going to work, so we're going to make assumptions about how it might work. And so if we know how something works and if it's successful, right, political will can be generated from that. And I just want to give credit to the conference organizers, because I know that what Gene was saying, who is an organizer, was against conferences. But I want to say that there is a value in conferences, aside from us coming here and hanging out in New Jersey and getting some good lunch. You know, this is an opportunity to kind of generate ideas, right, and build consensus around different ideas and proposals, and just get a sense of what's out there. And you also get a sense of what the weaknesses and the fault lines that exist with respect to ideas that are generated. And I think that this is kind of part of the mobilization effort towards reform. It has to begin at this idea stage. And then, yes, you have to get to that implementation. And I see my role as engaging in conversation and coalition building with those groups like Common Cause and Demos that can actually advance the policy or advance ideas on the ground and think about how this might look in different contexts and how it might be implemented.
Yeah, let me just say quickly, to avoid repetition, I do think that states and localities are critical sites here. And one thing I didn't have a chance to mention is that both Arizona and California are in signature gathering procedures. I actually don't think either is going to qualify for the ballot, but that there are ballot proposals to put a right to disclosure in the state constitutions, actually, in both of those states. And again, I don't think either is going to qualify for the ballot. And that does not in any way, that would not sort of overcome any federal First Amendment objections, obviously, to potential compelled disclosure, but it could have interesting both expressive and maybe substantive effects. So I think just, you know, Congress is an intractable problem, but there are a lot of sites, I think, of potential opportunity in states and localities.
Great. Brent, in the back.
Sure, I have a question for Kate. I thought your discussion of disclosure was really interesting, and I tend to agree with Richard right now that I think the jurisprudence is pretty safe, but I also know that we work on, and a lot of states are trying to improve their disclosure systems. You have covered transfer law in Connecticut. In New York City, there's a new law that requires disclosure of contributors several levels down for an IE group. And we actually put forth a bill in Missouri last month that combines those two. So I wonder if you've thought about or have an opinion on how the jurisprudence would apply to those disclosure laws, which I think are really necessary to make disclosure effective, and whether they pose greater constitutional problems.
Yeah, no, I mean, I guess I maybe probably should have said that obviously that right now, right, absent some change, the kind of core stuff that I'm talking about right now is fine. But I guess shoring up the sort of basis for these existing, I think, fairly modest requirements, I think is critical to the kinds of expansion efforts that you're talking about. So I don't want to be alarmist, but I do think that not taking for granted kind of the constitutionality of the sorts of things that we have always engaged in the federal system is important. I think that it is, you could see the sort of expanded efforts. Nothing that you're describing right now sounds like it would be facially deeply problematic necessarily on existing doctrine. But if I'm right that there is that it's thinner, right? That it's just the sort of just the vote count and sort of the kind of the recentness of some of the affirmations of the federal disclosure system a little bit maybe conceal what I think are vulnerabilities. But so I think that doing that is sort of antecedent to, and then I think if you can sort of do more work to kind of further shore all that up, I think there are real expansion opportunities. And so that obviously is where a lot of the really interesting and important action lies.
Great. I guess one last question from Kent, and then
Thanks, John, because I wanted to follow up on the disclosure point, and mostly for Kate. It strikes me that, and I appreciated your commentary. I think sometimes those of us in the progressive community put too many eggs in the disclosure basket.
Mm-hmm.
First of all, sometimes disclosure can be a bad thing. Like if I'm living in Birmingham, Alabama, and contributing to a Muslim candidate, you might not want your identity revealed. I took a group that I was the head of took a gay rights case in the Supreme Court during the Iraq War. And we fought hard to keep our membership secret, in part because we wanted to protect our members. The other thing is that disclosure only works when the people receiving the information can change their behavior based on that information, right? Like how many times have you renegotiated with your credit card company after you received a disclosure statement? Like me, zero. And also, I think this is Michael's point too, that sometimes disclosure can have perverse effects. Disclosure CEO pay had the exact opposite effect than what people thought. Because the CEO, like the CEO of GE was like, well, you know, the CEO of Walmart's making that much. I should be making that. You know, and so you start disclosing, you know, like GE's going to say, well, you know, if you know, Walmart's paying $100,000 to this candidate, we better as well. So I think it's easy for progressives to be too sanguine about disclosure, and I'm not against disclosure in all circumstances. It's just more problematic.
Yeah, go. I mean,
No, I'm sorry.
No. So I'll say a couple things, but I think others probably will. Yeah, no, and I think that both. Well, I think Michael certainly shares a lot of this sort of skepticism and wants to take very seriously the costs. And I guess I think it's a regulatory tool that it is important that federal, state, and local governments have at their disposal, but that I totally agree that we need to think very carefully about both costs and benefits. My intuition is that the benefits, in most cases, significantly outweigh the costs, but I think Richard, for example, has suggested that maybe $200 is too low in the federal system, and I don't want to misquote you, but 1,000, I think, is maybe what you have said might be a better. How much do we really learn from these kind of donations at the smaller end of the spectrum? I mean, I actually think maybe something, but there are other kinds of information that are compelled in the federal system. I'm not sure home addresses actually does much, and from the perspective of vulnerability, now campaigns, obviously people use PO boxes and that sort of thing, but I worry about harassment and sort of the way, kind of the gendered nature of online harassment and unpopular causes, and I think there are smart proposals out there for partial de-identification. I think that region and occupation actually provide more rich and interesting data to work with to try to understand and track influence. So I think there are categories that are, I think cost and benefits sort of shake out differently with respect to different kinds of categories of information. So I didn't mean to give short shrift to any of those concerns.
Yeah, and I fully appreciate the effort to bolster the record here and bolster the justifications, because we know there are efforts underway by the same architects that have been dismantling our campaign finance laws that disclosure is the last brick and they'd like to throw it out. I mean, there are multiple lawsuits all across the country challenging disclosure laws. Most of them have been failing. There was just a law in Delaware that was just upheld by the Third Circuit that we helped on an amicus brief on. But I'm distinguishing disclosure in the election context from disclosure of the litigants that you represented. And I think about three basic reasons for why we need these disclosure laws in place. One, because I do think voters have a right to know who is speaking to them. And hundreds of millions of dollars have now been going through these outside spending groups, and no one knows where the money's coming from. I mean, we talk about the Koch brothers, but really people don't know where it's coming from. Two, so that voters can hold their elected officials accountable, which is the language that Justice Kennedy included in Citizens United, and quoting Justice Scalia, so that we can know if our elected officials are in the pocket of so-called moneyed interests. And then three, just to enforce the laws on the books now to ensure that there's not circumvention and whatever else. So I am talking about it squarely within the election, the electoral context. And one other point, just looking at how political operatives are setting these systems up. Karl Rove spoke at the Annenberg School, in 2010. He set up American Crossroads, the super PAC that discloses, and Crossroads GPS, the C4, the sister organization, and is on the record said explicitly there were many donors that wanted to give to American Crossroads but did not want to be disclosed, and so we set up Crossroads GPS so that those donors could give to that organization. That organization then spent $71 million in 2012. I mean, they are on the record. That's why they set it up. They set it up specifically to provide anonymity to big donors. Crossroads GPS then disclosed to the IRS. It took a $22.5 million check, a $18 million check, a $10 million check, and many, many other $1 million checks. And if you look at the 990s, of course, the donor is just redacted.